Hello everyone, and welcome to our lecture recording for chapter 14, which will continue our discussion on the validity of contracts. And in particular, we're going to cover more in relation to the contents of the contract itself, or what's known as the terms of the contract. So let's get started with the first learning objective, which is on page 347. It asks us to identify terms in a contract and distinguish them from a representation. So the starting point really is on page 348, where it says, assuming that a simple contract has been created and that there are no elements that affect its validity, it may be necessary to consider exactly what it is that the parties have agreed to include in the contract. So in a sense, we're really saying that there is no problem with the validity of the contract, but we might still have problems with the content of the contract. So we could think of this as a third element in relation to our analytical structure. The first element being the existence of a contract, and under that we had three sub-elements where we looked at the issue of agreement, the issue of intention to create legal relationships, and the issue of consideration. Not really issues, but sub-elements of the agreement, the intention, and consideration. So all of that comes under the first element of the existence of a contract. And once we have established that yes, there is a contract exists, we can move on to the next element, which is the validity of contracts. And again, there we had four sub-elements. So we started looking at the ability or capacity to contract, and then we looked at consent and illegality. There's also the issue of form, and we will touch upon that maybe a little bit later in more detail, but it simply says that some contracts will have to have certain form. For example, some contracts will have to be in writing. Okay. Let's assume that our contract passed the test on existence and the test on validity. So we have a contract that's a valid contract. That does not end our really analysis of the contract, because now we have to open up this black box and look at what's inside. And that's where we are today. We want to look at the terms of the contract, the content of the contract. Okay. So basically we're asking, what is the extent of the rights and obligations that the parties have entered into? And as it says, the answer can be found only by deciding what the terms of the contract are. And we're given more details under the figure on page 348. So figure 14.1 gives us different types of terms. So as we said, we assume that a simple contract has been created and there is no elements that affects validity. Now we want to look at the terms. So there are different types of representations or statements that you could find in a contract. There's an in-brief box, again on page 348, that gives you a snapshot of what these are. So you find there is a term, in which case the statement will create contractual obligations, or there's a collateral contract that is a preliminary contract in which the paying contract is entered into. And there could also be a representation, okay, that induces an offeree to enter into the contract, but that is not part of the contract. Okay. And there's of course sales puff, which is basically not intended to have any legal effect. Now on this last one, on sale puff, you can also refer to or link that to the discussion on section 18 of the ACL, or the Australian Consumer Law, which you can find on page 469. And that comes under chapter 18, which we're not going to really cover in much detail, but if you're interested in knowing more about how that is treated under the ACL, you'll find that there's some further discussion of that on that page 469. Alright. So as we say on this slide, we have a statement that could either be a promise or that does not give a promise to the truth of the statement itself. And what we want to really get to is the difference between terms and representation. So you see that terms is number one, and that comes under a statement that promises the truth of its truth, or it could be a representation which comes under a different type of statements that do not promise their truth, and that will come under pre-contractual negotiations, in a sense, or inducements to enter into the contract. Okay, so as it says on the slide, simple representation is a statement of fact intended to induce a party to make a contract. Alright, these are the types of contracts, the types of terms rather, that we have on page 348. It talks about 3 different types of terms. So we have express terms, so you have oral, written, oral and written, and you could have implied, where you have custom or usage, or statute, or by the courts, and of course have the misleading type of terms that we'll also look at in some detail. Let's then start on express terms. So to determine then whether a statement is a representation or a term, we have to consider certain factors. So this is a follow up on what we had in the previous slide that distinguished between the statements that are terms and statements that are representations. Factors are given to us on page 349, and it says there are objective tests. So it says, in trying to ascertain the intentions of the parties from the particular facts before it, the court will take into account the following matters. The first one is how much time has lapsed between the making of the statement and the final agreement. So the longer the lapse of time between the making of the statement and the final agreement, the more likely it is to be treated as an inducement and not intended to form part of the agreement. The second is, was the innocent party asked to check or verify the statement? Here the statement is more likely to be an inducement. The third, was the statement made with the intention of preventing the other party from finding any defects, and did it succeed? And it continues with the list on page 350. So you will find that there is also the fourth factor: what importance did the parties attach to the statement, and did one of the parties have special skills or knowledge? Okay, so it says where one of the parties had some skills, special skills or knowledge not possessed by the other party with regards to the subject matter of the contract, then a statement would more likely be treated as a term, more likely a term. Now remember that these are only factors and not elements, in the sense that you just need to make some of these in order for you to tip the scales in the direction of a term or a representation, but you don't have to really make to be successful on each and every one of these in order for you to establish that the statement is a term or representation. So it's a matter of on the balance you can see that it's more of a term than it is of a representation. So it's a matter of degree, really. Unlike when we talk about elements, when we say elements, we mean that they are necessary for the making of the cause of action or the theory that is being discussed. So for the existence of a contract, you have 3 elements, and those 3 elements are a must. You have to have those elements. You have to succeed on each and every one of them in order for you to make that the case, or to argue that there is a simple contract. There are some exceptions. Sometimes, for example, consideration will not be required, as we saw under promissory estoppel, but we're talking about the general rule here is that if it's an element, then you have to make the element in order for you to establish the cause of action or the legal theory. Alright, let's then move on to our second objective, which asks us to discuss the parole evidence rule and the number of qualifications subject to it. Our discussion starts on page 351, and it says there that you have the parole evidence rule, and it talks about oral contracts and written contracts. So if you drop to the second paragraph under written contracts, it says, in the case of a written contract, the court generally will not admit evidence of acts or words of the parties prior to the execution of the document if it has the effect of adding to, varying, or contradicting the written agreement. So So this is because the course assumed that the party's intention is contained within the four corners or the text of the contract. This is a written contract, and this is known as the parole evidence rule. Okay, so the parole evidence rule simply says that if you have a written contract, the court will be reluctant to look at any evidence that comes from outside the written text. Okay, however, this rule is subject to a number of qualifications, okay, in order to try to avoid hardship or injustice. Okay, so you can admit oral evidence to prove a trade custom or usage, to show that the contract has not yet become effective, or where the court is of the opinion that the written document contains only part of the agreement, or to clarify any ambiguous language used in the contract, or where due to a mistake of the parties their agreement was not accurately expressed in the text, or to demonstrate that a description is false. So as it says in the business tip on page 152, where the agreement is written, ensure it contains all of the terms. Remember that in the case of a written contract, the court generally will not admit evidence of acts or words of the parties prior to the execution of the document, so this is the parole evidence rule, if it has the effect of adding to, varying, or contradicting the written agreement. While there are exceptions to this rule to reduce exposure to litigation expenses, ensure that all of the relevant terms are contained in the document and that there are no ambiguities. Alright. So we said that there are certain exceptions to the rule, and we said what the rule actually means. So it's a good time for you sometimes to just stop the recording here and write down whatever notes that you want to have on the slide, or go back and check again what you have in the textbook and so on. Let's then move on to the third learning objective, and says identify a collateral contract and explain the significance of its contractual effect. And that starts on page 352, where we say that there is the ability so if there is a statement that promises the truth of itself, the truth of the statement, but this statement is not part of the contract, i.e. it's not a term of the contract, you can argue that, so this is a legal theory where you can argue that this statement is in fact part of a collateral contract that came before the main contract, of which this statement is not a term, right? So this would give you the ability to say that there was a collateral contract, and the collateral contract was that it led to entering into the main contract. Okay, so oral promises made by the parties prior to entry into the main contract that are not terms, so they are promises but they are not terms, may have contractual effect as collateral or preliminary contract on which the main contract is based. Okay, and you'll give an example there in the case of De La Salle and Guildford on page 353. Okay, now in order for you to establish that, let's look at page 352 at the bottom, go down 3 lines to the end of the page. So it says, to prove that a collateral term or contract exists, the claimant has to be able to show that the statement was so important to them that but for it they would not have entered into the contract at all. Now this but for it test is actually something you will also see or you have seen probably before. So if you go back to page 145, you will find there that they talk about factual causation, and the factual causation looks at the but-for test as well. So it's a similar sort of test that looks at the reason for entering to the main contract. Was it but for this collateral term or collateral contract? And you'll find the elements for this cause of action or this legal theory are given to you on page 353. So it says, in order to establish a collateral contract regarding a statement of fact, it's necessary to show that the person making the statement intended, first of all, intended the statement to be relied on and guaranteed its truth, and there was reliance by the person alleging the existence of the collateral contract. Okay, so this is how you establish the existence of a collateral contract. Okay, now there are also criteria for enforceability, which are on page, so this is basically the validity of the contract on page 354. So just like we did for contracts, generally a simple contract structure where we said that you have to look at existence and validity, for collateral contracts it's really reduced to this analytical structure on these two pages, 353 and 354. And it says, as far as validity is concerned, once a collateral contract is established, it is valid and enforceable only if the plaintiff can establish each of the following. Again, three elements. The statement relied on is promissory and not descriptive or representational, and the collateral contract is not supported by past consideration, and the collateral contract is consistent with the main contract. Okay. Now this last part, the last element, is talked about in some more detail. At the bottom of the page says, will an exclusion clause in a business contract be overridden by a collateral contract or promise? We're going to talk about exclusion clauses in just a minute, but if there's a contradiction between the collateral contract and the main contract, and the reason for the contradiction is this exclusion clause, as it says on that page, on page 1054, if the inconsistency comes from the operation of an exclusion clause in the main contract, the collateral contract or promise will override, the exclusion clause, because it is the very thing that induces the injured party to contract. Okay, and you are given an example as well at the bottom of the page. I just want to draw your attention again to the in brief box on the top of page 1054. It says the significance of the collateral contract, where a pre-contractual statement is not a term of the main contract, it may still have contractual effect as a collateral contract, thus providing the injured party with a remedy. This is the injured party under the main contract. Such a contract has an independent existence to the main contract and may be enforced by an action for breach of a promise. More importantly, the collateral contract is not caught by the parole evidence rule because it is oral. So it is not caught again by the, so you can think of it as one of the exceptions to the parole evidence rule. Alright, so let's then move on to our fourth learning objective, that asks us to recognize the importance of different terms and identify conditions, warranties, and statutory consumer guarantees. You'll find these reduced for you in a bullet point format in the in brief box on pages 355 and 356. And we're going to start by looking first of all at two different types of contracts. So we're going to look at something called business contract and something called a consumer contract. So the business contract is what we call B2B. So it's between two companies or between two businesses. So the parties to the contract are companies or businesses. A consumer contract, on the other hand, at least one of the parties is a consumer, and that will bring in the ACL, as you know, that we have the Australian consumer law, and that becomes then the arbiter as far as terms, because now we talk about actually consumer guarantees rather than conditions, warranties on nominate terms as we have under the business contract. Okay, so if it's a business contract, the terms, okay, could either be conditions, warranties, or nominate or nominate terms, or it could be a consumer contract where the terms are not called conditions, warranties, or nominate terms anymore. They are simply called guarantees under the ACL, and more on that on page 359. Alright, so let's first start with these business then contracts and look at conditions versus warranties. So you have a condition is basically a vital or essential term based on the intention of the parties, going to the root of the contract and allowing the injured party the option of rescission. You can rescind the contract, so you can basically cancel the contract, and or damages. A warranty, on the other hand, is a term but of lesser importance, so you can only recover damages. Okay, you can't actually rescind the contract. And there's a different analytical structure that is called an innominate term, or an intermediate rather term. So it could apply either as a condition or a warranty. So that depends on the gravity of the breach. So we ask not the input but the output. We're looking at the breach rather than the intention. Ask whether innocent party deprived of substantially the whole benefit. So if they have been deprived of the whole benefit under the contract, it would be a condition and they can rescind. Or if it is a less substantial breach, then you could think of it as a warranty. That's why we call these innominate or intermediate terms. So to determine if a term is a condition or a warranty, we have something called an objective test. So it is part of the reasonable person thinking. So we look at the contract as a whole and consider if the stipulation is essential to the contract. You know, what would the reasonable person think? And look at the effect of the breach had, or look at the effect the breach has on the contract. And you are given examples of application of these tests as given to you on this slide. An important point then is on page 357 under the business tip. So it says parties who wish to have a degree of certainty that a breach of a particular term will terminate an agreement should spell out the effect of such breach in their agreement. So if you think that something so important to you in the contract, and without it you would rather just cancel the contract, i.e. rescind the contract, then you should state that expressly in the agreement, in the text of your written contract. So you have to say that if, for example, you can't deliver something within a certain time frame, I consider that to be a breach of a condition of the contract. I have the right, or reserve the right, to rescission and or damages, something like that. So it says if the parties rely on expressions such as condition and warranty, whether a term is a condition or a warranty will ultimately depend still on how the courts wish to interpret the term. So it's not just enough for you to say that, oh, this is a condition, this is a term, and so on. As we said, you have to spell out the effect of such breach in the agreement. That is a good, probably the best insurance that if something wrong happens, that you will be able still to cancel the contract or to get monetary compensation. Alright. Now there are also other classifications in terms of importance of the term, and some of these are given to us here. So we talked about conditions, and now we're going to specify more about condition precedent and condition subsequent. Let's start with condition precedent. So it says a term that prevents an agreement turning into a contract until the happening of a stated event. So for example, something like, unless I get finance for the pen that you want to sell me for $10, and unless I can get that money, we don't have a contract. So it's a condition precedent. Until I get the money, then we can complete the contract and I pay you the money and we execute the contract by you giving me the pen, for example. The most important thing is that the condition precedent is going to prevent, okay, the contract from coming into existence, and it has two types. So we could have a condition precedent to the existence of the contract, as if the contract will not exist, rather the contract will not exist until that condition materializes, or it could be a condition precedent to performance of the contract. Okay, so the contract exists, but in order for the performance to happen, to start performing our promises under the contract, something will have to happen first. Okay. Now there is also condition subsequent, which is on page 362, and it says a condition subsequent is a term in a contract that can terminate the whole contract or just part of the contract. For example, the death of one of the parties, the return of an item in exchange for another, or a refund if the item proves to be unsatisfactory. So this is a condition subsequent. It brings the contract to an end. Alright, let's move on then to our implied terms, and it says under the fifth objective, explain the types of terms implied into a contract. So in addition to its express terms, a contract may contain a number of terms that the parties or the courts may read into the contract. Okay, these are called implied terms. These are then terms that are not expressed in the text of the contract, but courts would read it into the contract, so they will introduce these implied terms into the contract. Okay, so there are 5 conditions that have to be satisfied for a term to be implied in the contract, and as you can see them on this slide in front of you, and there are also the types of implied terms at the bottom of page 362, where you see in the in brief box that talks about implied terms because of custom or usage, implied terms because of statutes or by the courts, or because the term is uncertain. So we imply terms because of custom or usage, or because of a statute, or because of the courts, or because the term is uncertain, or the term is meaningless. So for example, if the term is meaningless, terms for which the meaning cannot be ascertained and which the court will sever if possible. So the idea is that you will imply these terms into the contract in order for you to get over such problems in the actual or the original contract. So I'll leave the details for you to read on pages 363 to 364. Meaningless terms, we will just say a bit more about them before we leave this part. And that's on page 365. It says there, unlike an uncertain term where there is no real agreement, with a meaningless term the parties have agreed on something. Okay, the difficulty is that the terms may be worded in such a way that a reasonable person would be unable to determine their meaning. In such a case, then, the validity of the contract will depend on whether these terms can be severed from the rest of the contract and still leave it valid. So if you find that there's a meaningless term, you'll have to basically cut it out from the contract and try to see if the contract is valid without it. Okay, and you're given an example there of the Fitzgerald and Masters case from 1956 from the High Court of Australia, and I'll leave that for you to read. And as we said, the intention is that when we do our colloquies or lectorials, that we go through some of these cases to illustrate further what we have learned in these lectures. Now there's a guide to construing the words of a contract on page 366 in the in brief box. So it says, when construing, i.e. when you're trying to interpret the words of a contract, regard should be had to the following principles. The meaning of the word or words is to be determined in the context of the contract as a whole. With the interpretation of commercial contracts, a common sense approach should be adopted. It is presumed that the parties did not intend the terms of their contract to operate in an unreasonable way, and in determining the meaning of words, consider the legal effect of the term. As it says, in the case of an ambiguous term, so it has more than one meaning, that could have 2 primary meanings, each of which could be adopted without distortion of the language, regard may be had to direct evidence of the intentions of the parties, including evidence of the circumstances surrounding the making of the contract and the admission of extrinsic evidence to resolve an ambiguity. The extrinsic, including parole evidence, i.e. verbal evidence, supplements or explains the written instrument and may include direct evidence of the intention of the parties, including evidence of negotiations between the parties, previous dealings between them, and direct evidence as to what was in their minds at the time. Alright. Let's then move to the sixth learning objective that asks us to describe exclusion clauses and the approaches to their interpretation and the statutory protection available to consumers. Okay. Now, the key point the discussion starts on page 166 at the bottom of the page, but I want to draw your attention to the third paragraph on page 167. Drop to the second line. It says the effectiveness of an exclusion clause is a matter of construction of the contract as a whole, so the interpretation. So the guide that we just looked at becomes handy, taking into account the bargaining position of the parties. Thus, in the case of a commercial contract, the courts would be prepared to assume that the parties were in an equal bargaining position and able to seek legal assistance. Whereas in the case of a consumer contract, the parties might have been in unequal bargaining positions and the consumer might not have even had time to read the document. Okay? So these things come into play when you look at the enforceability of such clauses. And then the ACL also says something, so consideration also needs to be given to the impact of the ACL, or the impact that the ACL may have on the inclusion of such terms in consumer contracts. So this is in relation to the implementation of section 64, prohibiting the exclusion of guarantees by contract. It continues, however, remember to check what the contract is for, because if it is related to the supply of recreational services, as you recall, it may not be void under 64 of the ACL because of section 139A of the the Competition and Consumer Act allows suppliers of recreational services to exclude, so exclusion clauses limit or modify the application of consumer guarantees in relation to death or personal injury to consumers. We had a discussion of these things prior to this as well. And the business tip just below that, it says suppliers and manufacturers should ensure that they have a good working knowledge of the ACL. The consumer guarantees provide a more stringent guarantee of acceptable quality and introduce statutory remedies against the supplier and in some cases the manufacturer as well. Consumers no longer need to enforce their rights as a breach of contract. Alright, so we said that there are two types of, in order for us to ascertain whether an exclusion, exemption, or exception clause would be part of the contract or not, we would go through this two-element analytical structure. We first look at incorporation and then at interpretation. So whether the clause is incorporated into the contract, i.e. is it a term of the contract? That's the link with the rest of chapter 14. And then once we establish that yes, it's a term of the contract, we have to move and then look at interpreting it. So if it's a term, is it going to be effective in excluding liability? So the first element as to incorporation. And the question there is, has the contract been signed? Do we have a signed contract or not? So if yes, then the exclusion clause or exception clause will be binding whether this clause is read or not, unless of course there's fraud or misrepresentation, and you have the cases there to explain those points. However, if the contract has not been signed, there's no signed contract, then we have to ask ourselves the objective test of would a reasonable person regard documents as containing contractual terms. So the person looking at the documents, would they believe that there are contractual terms in these documents? Has a reasonable notice been given of such terms? And if onerous or unusual conditions brought to consumers' attention or customers' attention. So if this clause is in fact part of these documents, was it brought because it's of an onerous nature? So for example, if something happens, you have to pay a very large fine, then that has to be brought to the consumer's notice before they enter the contract. This is when the contract is not signed. Okay, there is no signed contract. So for example, when you go to a dry cleaners and you're just given a docket, for example, you haven't signed anything. Sometimes now actually they ask you to sign as well. Okay, were the terms included after the contract has been completed? And as well, you have to ask, can terms be implied by custom or trade? So this takes us back to the discussion we had on implied terms earlier. So this is the analytical structure in relation to incorporation. Is the exclusion or exception clause part of the terms of the contract or not? Once we've established that yes, it is part of the contract, then we have to ask ourselves, what does it actually mean? What does this exclusion clause actually mean? Okay, so where an exclusion clause is validly incorporated, so once we have cleared the first hurdle of incorporation as we looked at just now, and you'll find the discussion about that from page 368. This is incorporation from 368 all the way to page 374. Now remember that there's also a business tip on page 371 that says if the condition is particularly onerous or unusual, as we said, and one that would not be generally known to the consumer, the party seeking to enforce the condition must show that you had fairly and reasonably brought this condition to the consumer's attention, for example by displaying a large sign in a prominent position, or by making the condition marker the condition in red on a contract. So you have to do something to show the person that, look, this is unusual, this might be onerous, but that's the condition we need to have in order for us to enter a contract with you, and that has to be brought to their attention. That's the key point. Alright, let's then look at interpretation on page 774. Again, it says where an exclusion clause is validly incorporated, it will be strictly construed against the party attempting to rely on it. Okay, and this is what we call the contra proferentum rule. That's discussed as well on page 774. Or interpretation will be made according to the express agreement of the parties. Okay, so that's what we call the four corners rule. That's at the bottom again of page 774. So interpretation basically will be according to the express agreement. And so it says, so the exclusion clause only operates to cover a loss that occurred within the operations envisaged by the contract. Commercial contracts may be allowed because of the equality of bargaining positions that can exist between the parties, and the exclusion clause is to be construed again according to its natural and ordinary meaning. Okay, so this is a rule of construction based on the presumption or presumed intention of the parties in commercial contracts. And you remember what we said about the presumption of the parties in commercial contracts, of course the intention to be bound, but also what they want in relation to things like, for example, exclusion clauses. So again, it's presumption. So again, the starting point is to go and ask ourselves, what was the intention of the parties? What was the intention of the parties from a reasonable person perspective? What could or would the parties have intended entering into this contract? And from that we can ascertain then whether how to interpret this exclusion or exception clause. However, at the end it says, note the position in consumer contracts, okay, if there is inequality of bargaining power for the consumers. So again, all of what we're talking about here is about being able to enforce a higher degree of fairness between the parties. So if there are commercial contracts between businesses, so B2B, you don't have to worry much about that because the bargaining is of equal power basically. However, if it's between a consumer and a corporation, a consumer company, there's that inequality of bargaining power, and that's something that you need to take into account when trying to interpret this exclusion clause. That's of course an exclusion clause usually of the liability of this company in relation to the harm or loss suffered by the consumer. Alright. Now similar points in relation to indemnity clauses and guarantees, which you'll find on top of page 177. Again, it says the High Court of Australia adopted a strict construction approach to indemnity clauses and guarantees. They are to be construed strictly in the context of the contract as a whole. If the indemnity clause or guarantee contains an ambiguity, it will be construed in favor of the party providing the indemnity. So the ambiguity will be construed in favor of the party providing the indemnity. So a protection on the person that is responsible or liable for the indemnity. There's also a discussion of the ACL. In the case of consumer contracts, some examples of legislative intervention by the ACL. some examples of legislative intervention by the ACL that could be used to control the operation of exclusion clauses can be found in the sections given to you on that page. And that's all really that I want you to know in relation to the ACL. But if you're more interested in these things, you can look at chapter 18 and even chapter 17. That gives you a much larger sort of introduction to the ACL. We've looked at exceptions again to section 64 rather. The exceptions apply where goods or services are not ordinarily acquired for personal, domestic, or household use or consumption. And again, you'll find that that there is a fair and reasonable. So it says there, allowing a trader to limit their liability for the supply of goods or services as long as the clause, i.e., the exclusion clause, can satisfy the fair and reasonableness test. So that's in section 64A, subsection 3. And there's also the same discussion in relation to sporting and recreational providers from section 139A in the Competition and Consumer Act, or the CCA. All right. So the idea of being able to delete or sever an unreasonable exclusion or exception term is worth looking at in some more detail. So it says the ACL and unfair terms. So if the term is unfair, the term must be unfair in order for the ACL to intervene, and it must be a standard form contract. Standard form contracts mean that it's just a form that you sign. You know, for example, when you go and hire a car, for example, it's a standard form contract, or you can probably do it online. That's a standard form contract. Now, how do you define or determine fairness? So criteria for determining fairness: first, it causes significant imbalance in the rights and obligations. It must not be reasonably necessary to protect legitimate interests, or it would cause detriment to a party if it were applied or relied on. Okay. And of course, there's the issue with transparency of the term. It must be in plain English, clearly presented and available. The last thing we want to talk about there is the position of third parties. So the discussion here is on page 378, okay, and on page 379 says the position of third parties, okay, and there's a risk management alert on that page. It says third parties will not be protected because of the doctrine of privity, i.e. privity of the contract between the contracting parties, unless it's clear in the contract that they are to be covered. They are to be covered by certain liabilities and so on, or exclusion of liabilities. Now look at also the business tip, please, on page 178. It says a precisely drafted exclusion clause in a business contract may protect a party relying on it, as long as it can be shown on a proper construction of the contract that the parties intended not to be liable on the happening of the events envisaged on the contract. But note that the clause generally will not operate if three things happen: either if there's any deviation from the contract, so deviation from the contract will mean that the exclusion clause will become ineffective, or if the contract of the party relying on the clause falls, if the conduct of the parties relying on the clause falls outside the scope of their obligations under the contract, or the contract is a consumer contract, because under section 64 of the ACL, liability cannot be specifically excluded. So you cannot exclude liability if it's a consumer contract. Okay, let's go back to third parties, and there it says simply on page 79, where the clause has been correctly incorporated in the contract, third parties will generally not be protected. However, a third party exemption clause, this is what they know as the Himalaya clause, because of the case discussed underneath it, can provide protection to a third party who is not a party to the contract. So although there's this doctrine of privity, there's an exception to that doctrine in the form of this Himalaya clause, or a third party exemption clause. I'll leave that for you to have a look at. So it says for a third party to avoid the operation of the privity rule and gain the protection of an exclusion clause, they have to satisfy the four conditions set in the case of Scruttons, and these are given to you on that page. First, the contract makes it clear that that it was intended to benefit third parties. It was clear that the defendant was contracting for itself and third parties, and the defendant had the authority of the third party to make the contract on their behalf. And lastly, consideration has moved from the third party, i.e. the performance of an existing duty is good consideration if it is owed to a third party. Alright, and then you have a summary of all of this discussion on the exclusion of clauses in relation to the sixth learning objective for today, and I'll leave that for you to have a look at and use for your notes. And with that, we come to the end of this lecture on chapter 14, and the next lecture is going to take us through chapter 19. So we're going to jump all the way from chapter 14 to chapter 19. That's the next chapter that we will be covering in this course. I encourage you actually to have a look at all of the other chapters in between, but these are not going to be covered in your assessments or the final exam. But they're very good general knowledge for you to have a rounded understanding of the subject of business or corporations law. But our next topic is really going to be agency law. So this is the last part of our discussion on the topic of contracts, and the next one is going to be the agency law or agency relationships that are discussed on chapter 19 from page 514. And we'll leave it there, and we'll talk again soon.